our defense at the probable
You
cause
save
hearing.
some.
I understand, but I don't have anything to hide, and I would just like simply for them to have my side of the story, because other than that, they're just looking at me.
I will give it to the
They're
prosecutor.
just looking at me and just making assumptions.
I can give it to the prosecutor. The magistrate.
I just want it, filed today, so it's available to everyone today, whoever.
Okay, the way we would
Even
have
if
to
it's
file
just the
that is
prosecutor.
basically what I would have to do is I'd have to e-file that as a just as discovery, as defendants as our discovery.
Well, it's just a statement. It's just a witness statement.
Right, but that's what I'm saying. But I would have to file that as discovery. Have to e-file that once you're bound over. There is no mechanism in magistrate court really for me to file documents that would be considered discovery.
Okay, I mean, I'm not considering this guy. I'm not considering anything. I just want my testimony about the situation and through my eyes, because you have it through Oki's eyes and through Tina's and through hers and through Abby's and through Mike's and through all these police officers, and no one has it through mine. I got to briefly explain it to you under duress and in jail, but that's what happened.
But I don't want to share that with the state right now.
Yeah, she wants to.
I want them to have it. I want them. I want them to have all the opportunity they can to see that what they're doing.
Well, I'm not going to introduce this through the hearing.
Well,
I will share this via email. We're not putting a statement on the record in a preliminary hearing.
Yeah,
I want that statement right now. Involved with this case today for them.
It's not going to happen because the magistrate won't accept it.
You won't do it?
It's not that I won't do it. I can't get this in unless you take the stand. You are not taking the stand at a preliminary hearing.
Okay,
That's the only, but I can share it with the prosecuting attorney as basically reciprocal discovery.
Well, then that's fine. Then just share it with the prosecuting attorney then.
Yeah. I can do that. And but I can't, like I said, I can't get it in unless you actually testify. Then I can get it in, but I don't want you to testify.
Well, I already emailed it. You guys have e-filing, I'm sure.
Yeah.
So you could e-file it right now. It's immediate.
Well, I can't till your case is bound over because there's no case number inserted.
Look at him, what they've done to him.
I know that doesn't make any sense, but that's just the way that's just the way it works. I can't e-file anything in magistrate court. That's not allowed. I can't get this in magistrate court as a document in the case unless you testify. I can, once the case is bound over, I can e-file it as reciprocal discovery. I will also make sure that Mr. Williams has a copy of it today.
So she's giving
Williams is
the
prosecutor.
Yes.
Yeah.
But it won't be available to the magistrate.
No.
And why is that?
Because I can't get it in
unless
you testify.
But you could give it to them directly if you gave it to
the prosecutor.
You can give it to the prosecutor, and you can give it to the magistrate directly.
No.
If you're giving it to the prosecutor, you can give it
to the magistrate.
You can't say I'm giving this to the prosecutor, and I made a copy for.
Mm-mm.
She needed.
Well, that's fine. Just the prosecutor can have it.
I wish that I could, but I can't.
And the motion for dismissal.
Yeah.
Anyway, that filed. However, even if it's just given to the processor, a motion for dismissal, and I want to know if Jeb is on the Brady list.
Okay.
Thank you, Kathleen. We'll see you over there.
welcome.
Thank you.